My lady, my lord, before then I move to the conviction grounds. If I can just deal with two further aspects of the evidence and ask the board again to just have reference to the respondent's written case. And I'm at paragraph 10, where there's an invitation to the board to have specific regard to certain passages from the record. And if I can just expand, if I may, at little e, which deals with the appellant's evidence, where I invite the board to note the following in particular. First, there's no evidence from the appellant that he was suffering any symptoms of schizophrenia at the time of the killing. And if I can just expand on the footnote there at 5, I apologise for the small type. There's a reference to the transcript, and if I could invite you to open volume 1 at page 201, please. And this is the evidence that was given by the appellant at trial. It's towards the end of the cross-examination. And at the bottom of 201, he's being asked questions by prosecuting counsel. If I can pick it up at line 21. You remember when this matter was at Half-Tree Court? In answer, no, ma'am, I was a sick person at them time. So you never see witnesses come to court? No. Then over the page, you never see any witnesses? No, ma'am. And then prosecuting counsel sits down, and then there's a brief re-examination by Mr. Harrison. And he starts, you're a sick person, answer, yes, with my nerves. Question, with your nerves? Yes, sir. And I think you're saying that you were sick at the preliminary inquiry time? Yes, sir. Have you been treated for that? Yes, sir. How long? He answers, I was taken to Bellevue Hospital when I was at Half-Tree Police Station. I went to see GP Dr. Leverage treated me. I also went to Ward 21, then asked which hospital, University Hospital. And then there's a question asked about the firearm, and he answers, I never fired a firearm before, and that's the end of the re-examination. And the reason I take the board to that is that's the only evidence that was led by the appellant at trial that made any reference to an illness. And I say it is quite telling that Mr. Harrison, in his re-examination, limits it in the way that he does. He does not, for example, ask any further questions about the mental condition when that would have been an opportune moment for him to do so. And I say when that is taken with what I say is the clear evidence from the transcript that he had a copy of Dr. Otti's report and had knowledge of the appellant's mental condition, that supports the respondent's submission that it was a clear tactical decision taken not to raise diminished responsibility, and more than that, not to put the medical evidence as to the appellant's mental condition before the jury, before the judge. So, picking up further then at little e in the written case for the respondent, noting then that the appellant's case has constantly been, to this day, and we know that from a medical report that was served from an examination that happened yesterday, that he's maintained his innocence throughout. And there are various references, and I won't take you to the passages of the record, but footnote 6 at the bottom of page 652, which is the respondent's written case, notes a number of references after the offence to the appellant maintaining his innocence, at one stage saying on the 30th of March 2011, he remembered why he was here, and he says it's because he ran out of the place and the man who committed the act ran after him.
So did you say there's a medical report of yesterday?
Served on the respondent, there's been if your lordship will recall, Dr. Sewell examined in August 2014. Yeah. Dr. Sewell examined the appellant again, I'm led to believe, yesterday. Right. The report isn't before the board.
Not before, no.
And
I think I did mention it, and I think we handed it in this morning.
Something's just arrived on, I imagine, everybody's desk from Dr. Sewell.
I summarised it as saying that he's all right provided he's on his medicine.
Dated the 2nd of December. That's the thing. And seen on the above date, page 2. Yes. So he has seen him again.
You want another copy, Mr. Poole?
my lord.
Probably there. Thank you very much. All right.
Does this one say anything about his account of the allegation, Mr. Paul? I don't think this one does it? But the previous one did.
The previous report, yes, in August 2014, he makes reference in that to
Top of the final
off-
page, Mr. Brown maintains he's not guilty of murder. He continues to have the capacity to fully understand the nature of the offence he was convicted of, its disposal and current action.
my Lord, indeed, and there's an earlier reference on the second page of it that mental status examination, second paragraph, orientated in time, place, person. His memory was intact, his cognition was normal, he had good insight into his current circumstances and his judgment was normal. But in answer, yes, to my Lord Hughes' question, at page 455, that is the third page of Dr. Sewell's August 2014 report, and that's where it's recorded. Mr. Brown reported he was living in Nannyville at the time of the incident and had become non-compliant with his medication.
Yeah, and then the instructions about what happened at the time of the death.
Yes.
Which is it the same account that he gave to the police, which was proved at the trial,
Yes.
and the same account that he gave in evidence at the trial?
Broadly similar.
More or less, but there are one or two
two.
differences, yes.
Sorry, could you just remind me of the page reference for Dr. Sewell's?
It starts, my lady, at page 453, and the paragraph we're looking at the moment is 455 under the subheading Report on Index Offence.
Right, thank you.
I suppose just for completeness on
I suppose he does have the non-compliant with his medication. What he does.
my lord, and that's the point I was just going to expand on. There are only, I think, two references in the evidence to the appellant actually saying something of relevance about whether he was on his medication or his symptoms at the time of the offence. This is one of them, August 2014, so a number of years after the offence. And he also says something very similar when he's interviewed by Mr. Wright, which is recorded in Mr. Wright's first affidavit at page 337. At paragraph 32 of that affidavit, it's recorded, I asked about the appellant's medical condition at the time of his trial in January 2003. He said he was very ill at the time. And then, so that's talking about at the trial in 2003. And then on page 336, at paragraph 27, he talks about the date of the offence. And he says, the appellant said at the time of the murder of Errol Lynch in September 1998, he was very ill and was not taking his medication. He said that he did not commit the murder, but was at the scene of the crime trying to buy ganja from Lynch, who was his weed man. He said he now knows it was two men known as Killer and Shotter who committed the crime. He described Arthur White, the eyewitness, as a cokehead. And perhaps it's worth noting there, that's Arthur White, who he subsequently, in his evidence, denies knowing at all, which is one of the points that is said was not put to Mr. White at the preliminary examination by his then counsel. But those are the two, so at around the same time, several years after the offence, 2014, they're the only evidence we have from the appellant that suggests that he was, A, not taking his medication, and there was some, that he was ill at the time. What is telling, though, is that he does not expand on that, does not refer to any symptoms, or does not give any evidence as to how his symptoms of schizophrenia may be operative at the time.
Well, he might or might not have known that.
My lady, he might not have known that, but obviously at the date of the trial, which we say he was clearly fit to plead at that stage in 2003, and when one looks at the medical evidence, and in fact Dr. Sewell's most recent report, his memory is intact. What we don't have is any medical evidence suggesting, for example, that he might have been able to convince himself that he didn't play any part, and that might be a symptom of his schizophrenia. There's no evidence as to that. And his consistent account has always been, I was there, I played no part. Just picking up the written record and just to finish this point on the appellant's evidence, the top of page 653, the evidence was that the appellant was at the deceased property at the time of the killing. Afterwards, he threw away his jacket, and one of the reasons he said he threw away the jacket is because it might incriminate him, because people might say that he was the killer. And there's the reference there to page 169, lines 5 to 14. The appellant also denied material parts of his statement under caution. And then when charged with the murder, said, I don't know nothing about any murder. They're what I say are relevant aspects of the appellant's evidence. The last point on the evidence, and really by reference to the transcript I wish to make before dealing with conviction, is picked up at little g on page 653. This is what I say one should properly infer from the transcript. And so, first, I say that it is quite clear from the remarks made by Mr. Harrison following the verdict that he knew the appellant had been certainly remanded in custody for several years, and that expert medical opinion had been sought as to whether it was fit time to proceed. And that, I won't, unless the board wishes me to, take you back to the transcript. The reference is given there at G, and you were taken to that passage by Mr. Guthrie. At little h, when one deals with then the plea and mitigation, there is a reference by Mr. Harrison to the appellant's mental condition and the need for obtaining medical reports from doctors Leveridge and Otti. And then there's a particularly important passage in my submission. If one turns over, summarised at little I, in the written case. And that, I will invite the board to turn over. It starts at page 262, and I will take it fairly quickly because it will be a passage that the board has already been taken to. If one starts at line 14, when I spoke about, my lord, the figure proffered, I was thinking in terms of the parole, the question of parole. Then Mr. Harrison says, I really believe, my lord, that there is a very real sense in which I have pondered, and I am being candid with the court, I have pondered, and the offence may not have been committed during the kind of period that I say he sometimes doesn't recall what happened yesterday. I say that is clear reference there to Mr. Harrison certainly turning his mind to the appellant's mental state at the time of the offence. And he uses the word pondered twice in that passage. He then, if we turn to 263 and pick it up at lines 4 to 7, he makes reference to the appellant having been diagnosed with one of the more serious conditions. The passage that below that, starting at line 13, is the judge quoting from Dr. Otti's second report. And just pausing there, in my submission, if this is the first time, as I think it's possibly being suggested by the appellant, that this is the first time the judge has seen Dr. Otti's report, it's fairly extraordinary then that it's not introduced at all. There is no comment made about it, as one would expect. The inference I would invite the board to draw is that the judge clearly had that report at his disposal and takes it upon himself to then quote relevant extracts from it. And then
I don't quite know whether that was a bundle prepared for the sentencing purposes, or do we, or for any other purpose, do we?
The report, my lord.
Yes.
The report,
I mean the bundle, the bundle the judge had.
I'm sorry, no, we don't. And then perhaps the most contentious passage is over the page, at the top of page 264. And there's been already much debate about this, where Mr. Harrison says, if I had that kind of information, then there may have been a different approach to the conduct of the defence, the question of the level of responsibility. And just so the board has my submission on that, I say that the only clear and natural reading of that is that the reference to that kind of information is information that the appellant's behaviour at the time of the offence would have been suggestive of symptoms of schizophrenia being operative. It cannot, on a natural reading, be a reference to Dr. Otti's report. If I can move from
I'm not sure I follow that, Mr. Paul. If I had that kind of information,
yes,
you say there's not a reference to Dr. Otti's report. Is it a reference to the information in Dr. Otti's report?
I say no, my lord, because what in my submission Mr. Harrison is talking to you there is information that would really support a defence of diminished responsibility, and all he has got. My submission is Dr. Otti's report, where you have a single line really reciting the relevant law, doesn't expand on the reasons why Dr. Otti has come to that conclusion, and merely says substantial impairment at the time of the offence.
So you're saying that when Mr. Harrison says that kind of information, if I'd had it, he's not referring to the sentence quoted by the judge where Dr. Otti said it's likely that the illness would have caused substantial impairment?
He is, and let me be clear, and I apologise if I haven't. He is not referring to the report itself, but he is picking up on what Dr. Otti says and what the judge has quoted.
Why?
And he's saying, if I had evidence that there was substantial impairment at the time the offence was committed, then I might have run the case differently. And I think the point that is being made by the appellant is that this is supportive of the appellant's case that Mr. Harrison really was taken by surprise by Dr. Otti's report, and there being a suggestion of a substantial impairment. And really, I think what the submission amounts to is this is the first time that the judge and Mr. Harrison have really seen Dr. Otti's report. And in my submission, I say that that's not a natural reading of this. And also when one takes the evidence that Dr. Otti's report was prepared really at the instigation of Mr. Harrison, as we saw in the contemporaneous notes, what I say this is Mr. Harrison saying, if I had evidence that would have allowed me really to run diminished responsibility, i.e. substantial impairment of the mental state at the time the offence was committed, then I might well have run the defence differently. Obviously, subject to instructions, but...
Very well, thank you.
Well, if I then, lady, move to points on conviction, really there are two main points on conviction. First, fitness to plead and stand trial, and second, broadly stated, safety of the conviction in light of the diagnosis of schizophrenia or the mental evidence as to mental condition. And I propose to deal with them in that order, and perhaps take fitness to plead slightly quicker than the fairness to trial point. The respondent's case, shortly stated on fitness to plead, is there was no barrier to a trial following a jury finding of unfitness. And that is set out at paragraphs 17 to 19 of the respondent's written case. And we say that is a natural reading of section 25(1) of the Criminal Justice Administration Act 1960, which was the relevant law at the time of the trial. And whether upon arraignment as here or at trial, there has been a jury finding unfitness, that does not prevent a subsequent trial, providing, obviously, the defendant recovers and is no longer unfit. And we say there is no statutory provision, common law rule, that there has to be a judicial or jury determination as to fitness in order to permit a once unfit defendant to stand trial. And we also know that the practice from the DPP's letter is that once a defendant has been found unfit, they would be treated, regularly assessed. The hope, obviously, that they recover. And in the case of schizophrenia, we know with treatment it is often the case that there is a significant and fairly speedy recovery. And once a psychiatrist has assessed them as fit to stand trial, that is sufficient. But obviously, picking up on
Unless presumably there's an issue.
my lord, and that's what I was just going to say. Picking up on your point earlier. If, of course, what happens if there is a medical report saying you're fit and the defendant wishes to dispute that, then there may well be a triable issue on fitness. But whereas we have the situation here, psychiatric report saying that the appellant was fit to stand trial, there was clearly no issue raised by the defence, and it would be entirely unnecessary in my submission to convene a hearing to determine fitness in those circumstances. The appellant advances 4 arguments as to why the board should really prefer their reading of section 25.1. And it does, to some extent, come down to an issue of statutory construction. Their first argument is, and perhaps it would assist to have the wording of the provision to hand, which is under tab 26, and it's at page 1039. And perhaps necessary to observe initially that the wording of section 25.1 of the 1960 Act is identical wording to the Criminal Lunatics Act of 1800 in England and Wales. And I won't take you to it, but under tab 32 you find a copy of the 1800 Act. And the appellant's first argument is effectively, if one looks at the words in the 4th line, such person cannot be tried upon such indictment, they say that is an answer to their point. That supports their finding that there has to be some kind of judicial or jury determination. Well, in my submission, there are 3 points in answer to that. First, I say, well, the words relied on only apply to a finding of unfitness at arraignment on a proper reading of that provision. Because if one reads, if any person indicted for any offence shall be insane and shall, upon arraignment, be found so to be by a jury lawfully impanelled for that purpose, so that such person cannot be tried upon such an indictment, or if upon the trial of any person so indicted, and then reading on, it shall be lawful for the court before whom such person should be arraigned or tried as aforesaid to direct such finding to be recorded. So the words cannot be tried upon such indictment only apply to a situation where you're arraigned. And my first point is that those words simply mean that the proceedings should not continue beyond that arraignment to trial.
Well, that's what Mr. Guthrie says happened. He was arraigned in 2000, he was found unfit, and says Mr. Guthrie, end of story.
My lord, I say, but what those words do not and cannot mean, on any sensible interpretation, is that sort of acts as a bar to a subsequent trial, or requires some judicial or jury determination as to fitness. And perhaps my second point makes good.
Well, you can always be rearranged, can't you? It happens all the time. It happens whenever anybody wants to change their plea for a start, but there are lots of other situations as well. So anyway, yes, all right.
My lord, well, perhaps the second point might make good the first in this sense. If I'm right that those words only apply to an arraignment, then you'd have a rather peculiar situation that Mr. Guthrie's argument only applies to the finding of unfitness following arraignment. It doesn't apply to a finding of unfitness at trial. And that would be a rather peculiar outcome, but would be the outcome if you read the statute in the way that Mr. Guthrie invites the board to read it.
If the jury verdict were final for all time, then a decision that he was not fit to plead would result in his lifelong incarceration.
Well, that's the rather peculiar outcome of the appellant's argument here. If the argument is right, then the situation is that the appellant is detained at the Governor-General, or now the court, following Mollison's pleasure.
You'd never have an opportunity of establishing that he didn't do it.
Well, no, I think Mr. Guthrie would probably say he would, but there would have to be there would either have to be a jury determination or a judicial determination.
Well, that assumes that it's not final for all time, that some procedure can enable a trial to proceed.
Yes. Yes. And the third point, and just really on the construction point, I say when one reads the provision as a whole, it only applies so long and until the pleasure of the Governor-General is known. So in other words, there's a wide discretion given to the Governor-General as to how to dispose of the matter after a finding of unfitness. The second of the appellant's arguments,
What do you mean he could send you home?
Well, he could.
Yeah.
yes,
We can certainly send you home.
Yeah.
What matters is whether he can send you back to the court if
Yeah.
you've tried again.
now, the second of the appellant's arguments, perhaps I can deal with this quite
You
quickly.
can't have an absolute discretion, surely, the Governor-General to send you back to be retried, can he? At any rate, absolute. I mean, he might have such a power if there's a change of circumstances. But there'd have
And if
to
he
be a
sent
change
you
of
back when you were
circumstances.
still just as
Quite.
insane as this says, as you were first time, that would be a bit fruitless because on arraignment you'd have the same situation.
Exactly.
So he can only send you back if he has reason to believe.
No, and
Will
this
it?
and this ties in with what we're told the practice and procedure was by the DPP at the time, and subsequently after the Act was amended in 2006.
But everybody agrees he doesn't have to keep you incarcerated forever. The only question is what the procedure is for sorting the matter out.
The appellant's second argument, as I say, I won't dwell on it too long because it didn't really feature in the oral submissions, but it's in the appellant's written case, is the appellant relies on the Criminal Procedure Insanity Act 1964 in England and Wales. And this is set out, or rather the respondent's case on this is set out in paragraph 22 of the written case. And perhaps it's necessary to again look at the statutory provision there and acknowledging immediately this is a different statutory scheme. It appears under tab 33. And it's section 4.1.
You said that in your case, haven't you?
My lord, yes. And the short point is,
Page.
page of the statute is at 1081, my lady,
Thank you very much.
where I set it out in the case at page 658. And I say really this doesn't assist the appellant's argument at all, because again on a proper reading of section 4.1, where on the trial of a person the question arises whether the accused is under a disability, that is to say under any disability such that apart from this act it would constitute a bar to his being tried, the following provisions shall have effect. And the reference there to it would constitute a bar is a reference to the disability itself rather than the finding of unfitness. And we rely also on the case of R.H., which is at tab 12, page 840, and a passage of Lord Bingham for their paragraph 10. But again, this is all set out in the written case, and I won't, unless you wish me to take you to it. The third argument the appellant relies on is amendments that were made to the 1960 Act in Jamaica, because in 2006 the entire scheme of unfitness to stand trial and to plead was codified, and in particular there was an introduction, and again rather than talking in the abstract, I can take you to it. It's under tab 27. And under tab 27, you'll find the 2006 scheme starting at section 25. And what is relied on by the appellant specifically is section 25C, which is at page 1048. Specifically section 25C little 3, which reads, a verdict of unfit to stand trial shall not prevent the defendant from being tried subsequently if he becomes fit. And in my submission, all that is doing is clarifying, if it needed clarification, and codifying the existing practice prior to 2006. And I think the way the DPP puts it in her letter, she says it is improving the language of the statute. But I say that is merely confirming what the position has always been. And the fourth and final argument is an argument that relies on the case of Hassani, which you were taken to. Now, the question of law and Hassani just is at tab 13. And the question of law that was determined in Hassani is specific, in my submission, to the statutory scheme in England and Wales, contained in sections 4, 4A and 5 of the Criminal Procedure Insanity Act. And the outcome in Hassani was arrived at in my submission to prevent a jury having to decide whether a defendant did the act or made the omission in circumstances where he was fit to stand trial and play his part in the proceedings. In other words, what happened in Hassani is there was a Section 4 finding of unfitness, and then the judge gave directions for a Section 4A hearing to determine whether the defendant had committed the actus reus of the crime. And before that Section 4A hearing could take place, the defendant was determined to be fit again. And so the practical step that was taken in that case...
Well, he asserted that he was fit and produced a report from Dr. Measy to say that he was.
Yes. Yes, my lord.
Go on from
yes.
there.
And in those circumstances, what actually happened is there was then a trial, a full trial, rather than a trial as to whether the defendant committed the actus reus or not. And what the Court of Appeal on the Judicial Review application found is that was, on this particular statutory scheme, wrong, because there should have been a second Section 4 determination.
Well, had there been a trial, or was it just that the judge had directed arraignment and the proceedings in the divisional court intervene?
Yes, the latter.
I think it's that.
Yes. Yes, an application for judicial was made to effectively prevent the trial, having
because it was the appellant's case that, having once been decided to be unfit to plead, he was entitled to be dealt with not by way of trial but by way of the separate Section 4A determination of whether he did the act.
Yes.
The result of which, of course, would have been, if that had been the case, that the disposals available would have been limited to those available to people who are unfit to plead. And that's what the court said was not the law. But it did also say, didn't it, for some reason or other, in paragraph 15, that Judge Samuel's direction that the trial should proceed was quashed, and he had to do it again.
Yes, which is why the appellant relies on it for the passage in the third line that says it's important that the procedure be followed even though the outcome seems clear. Yeah. And in my submission, you cannot discern a principle from that case dealing with an entirely different statutory scheme where the purpose of the second Section 4 hearing was effectively to prevent a completely unnecessary hearing, given that there was evidence that the appellant was fit to stand trial.
But even under Section 4, I mean, Lord Justice Hooper is usually right about these things. Why?
But I was thinking about not looking at a weak court, is one, in this case.
But what the board can...
Even strong courts can be wrong, we all know that.
Anyway, there we are. That's what
the board can be satisfied of is that what we don't have in Jamaica, or didn't have in Jamaica in 2003 and still don't have after the reforms in 2006, we don't have the same procedure, namely we don't have Sections 4 and Section 4A procedure. And I say that the reasoning in Hassani should be confined to its own specific facts and on the specific statutory scheme that it's looking at in England and Wales. So in conclusion on the point of principle, I can call it that, on fitness to plead, we say there's no basis in statute, common law, practice or principle for the appellant's submission that you, following a finding of unfitness, you have to have a further judicial determination or jury determination in order for there to be a trial. If I'm wrong, or let's assume the appellant is correct, the issue of fairness would then still need to be determined. And we say, for the reasons set out in paragraphs 26 to 41 of the written case, there is clearly no miscarriage of justice in this case. And the issue of raising unfitness to plead before this board as a final appellate court has been considered in a number of cases. It was considered in the case of Tate and Nigel Brown, and the relevant extracts from those cases are set out in paragraph 27 to 28 of our written case. I don't propose to take you to the authorities, but perhaps invite you to just look at paragraphs 27 and 28. What I draw from those is that, as stated by Lord Hope, particularly in Tate, there needs to be highly persuasive evidence that points very clearly to the conclusion that the appellant would not have been fit to plead. And the position here is that there's, first, no evidence that the appellant was unfit to stand trial in January 2003. And second, the weight of evidence points to the contrary, namely that he was fit to plead. And to make good those points, at paragraphs 33 to 37 of the written case, there are sort of really 5 submissions or 5 evidential points. First, you have the psychiatric reports of Drs. Otti and Leveridge, recording fitness to stand trial. Second, you have the contemporaneous medical records that show the appellant's condition being well managed by medication and under control at the time the trial took place. Third, you have the appellant's behaviour in my submission during the course of the trial, which is consistent with the medical evidence. The evidence he gave was coherent. He responded appropriately to fairly extensive cross-examination, and he put forward an exculpatory defence. Fourth, the trial was conducted by experienced defence counsel. You have Mr. Harrison, QC. And some further points to note in that regard. I think even on the appellant's case, Mr. Harrison was aware that the appellant had previously been unfit to plead for several years. We know that he met the appellant on at least 2 occasions prior to trial, each lasting for 1.5 hours, and the reference for that is at 359. The report from Dr. Otti of fitness to plead in November 2002 was specifically commissioned for Mr. Harrison. And in fact, the appellant himself says that Mr. Harrison knew that he was ill. And that's a paragraph from Mr. Wright's first affidavit that I took you to earlier. It's at page 337. And then the 5th and final point is that the judge himself was able to observe the appellant's conduct and fitness during the course of the trial, which lasted 5 days. So in my submission, in conclusion on whether there's been a miscarriage of justice, I say no, the appellant on any view was clearly fit to stand trial in January 2003. Moving then to the second point on conviction, broadly stated fairness of trial. For the board's note, this is dealt with at paragraphs 42 to 84 of the respondent's case. And as I had understood the appellant's case, it really boiled down to 3 broad points. Certainly the written case. It was first the admission of the deposition evidence of Mr. White, which now I think also encompasses and extends to the admission of the appellant's statement himself, I think it is now said, is questioned. Second, the failure to raise diminished responsibility. And third, the wider use of medical evidence. And I propose to take each of those arguments in turn. So first to deal with the deposition evidence of Mr. White. And I don't want to disagree with my Lady Hale. I had not, and it's in our written case for this reason, I had not understood the application for permission to the board to make any reference to this argument, i.e. the argument that the deposition evidence of Mr. White is called into question by the fact that the appellant was unfit to stand trial at the date of...
I can't recall whether that was in the application to the board. It was clearly in the case presented for this appeal, because I had written down the issues in my notebook.
My lady, in that case, I'm not going to disagree with you. I thought, and incorrectly, that you were saying it was in the permission application, because the point that's made in the written case, and I don't say I'm not prepared to deal with it, I obviously will deal with it, but it is a new point. And I do say the board should approach it with some caution, because it is a new point that raises a question as to competence of counsel. And competence of counsel here is not Mr. Delano Harrison QC, but it's Mr. Harrison who represented in the preliminary examination. Because taken to its logical consequence, what is being said is effectively Mr. Harrison, representing at the preliminary examination, did not do his job properly because he did not raise any issue as to fitness. Because it is being said fairly starkly by the appellant, it is clear, beyond any doubt, that the appellant was unfit to stand trial at the date of the preliminary examination in June 1999.
You probably do need to deal with that, but I'm not sure that that's the principal point that's made. It's, I think, more that because the defendant was or may well have been unfit at the time to give instructions, counsel, however competent he was disabled from effectively cross-examining Mr. White. I think that's how it would. I've been trying to think for myself what else one might have put to Mr. White.
Right.
Well, that's a question for Mr. Guthrie, not for you.
Well, my lord, it may be a question for Mr. Guthrie. I think I know Mr. Guthrie's answer, and it will be said. What should have positively been put is that the appellant did not, or Mr. White did not know the appellant, and it's rather peculiar because obviously Mr. Delano Harrison at trial didn't have the opportunity to cross-examine Mr. White, but obviously did have an opportunity to cross-examine the police officer and advanced a case on behalf of the appellant. But when the appellant gave evidence, he seems to have sort of gone off script, and which is not unusual when a defendant is giving evidence and face looking at the jury. But what he does do is he rather expands on his exculpatory case. And he goes as far to say, well, I don't know who this Mr. White is. That doesn't appear. That perhaps would have taken Mr. Harrison QC by surprise. But that really is all that is being said, should have been put, my understanding anyway, should have been put at the preliminary examination. Because it is right to note that there was fairly extensive cross-examination at the preliminary examination of Mr. White. But, my lord, I think properly analysed, it does call into question the competence of Mr. Harrison, because even if you're representing at a preliminary examination, you have to be satisfied that your client is able to give proper instructions, and you have in the bundle the cases of Campbell and the cases of Lawrence, which are summarised again, and perhaps I only need to take you to the respondent's written case, the summaries at paragraphs 66 and 67. And the principles derived from those two cases, stated shortly, is that the board ordinarily won't entertain a ground of appeal based upon the allegations of incompetent counsel raised for the first time, particularly in circumstances where counsel could reasonably have decided not to, for example, run a particular line of argument or seek a particular direction. The difficulty here is, whereas Mr. Delano Harrison has been asked for his comments on mental capacity and the conduct of the trial, Mr. Harrison, from the preliminary examination, as far as I'm aware, has not been asked to comment at all. So there is a vacuum in respect of Mr. Harrison from the preliminary examination. The dealing, though, with the substance of the submission, first, I say there was nothing unfair about the way in which the preliminary examination was permitted to take place. And the second point is, even if there was some restriction on the appellant's ability to instruct counsel, this did not have a sufficient impact on the trial so as to render the conviction unsafe. So expanding on those 2 points, dealing first then with the fairness of the preliminary examination, and this is dealt with at paragraphs 45 to 50 of the respondent's case. We know Mr. White's deposition was admitted into evidence pursuant to section 34 of the Justices of Peace Jurisdiction Act. We have evidence, or at trial there was evidence from the court clerk that was present at the preliminary examination. He gave evidence, and it's at Just give me a reference to the transcript. It's pages 70 to 74, and then again at 127 to 129. And the effect of his evidence at trial, when talking about the preliminary examination, was to confirm that all procedural steps were followed in respect of the requirements of Section 34. But I accept that the question really is whether the appellant's counsel had a full opportunity to cross-examine Mr. White, because that's really the attack here. The appellant bases that attack on, they say, it can be stated with practical certainty, is how they put it in their case, that the appellant was unfit at the preliminary examination. Well, I say there are four problems with that submission. First, there is no contemporaneous medical evidence to support such a finding. What you have is either sort of bookending, really, the preliminary examination. You have something from January 1999, which I accept suggests that the appellant does not understand the charge, and there's a reference to that at page 370. And then you have a report from Dr. Otti, the first report, in June 2000, and that's at page 571. So in other words, you have some medical evidence 6 months prior to the preliminary examination and some evidence a year after, but nothing at the relevant time. The second problem with the submission is that the appellant was represented by counsel, and this really does go to the point I alluded to a moment ago about competence of counsel, because one would have expected competent counsel, if there was an issue as to fitness, to raise that, and one, in my submission, can safely infer that counsel at the preliminary examination felt able to properly put the appellant's case by way of cross-examination of Mr. White. And as Mr. Guthrie, in my submission, correctly noted, it is slightly unusual at a preliminary examination for the witness to be cross-examined, because often the defence wants to keep their powder dry. Yeah. And there was fairly extensive cross-examination, and you have the reference Mr. Guthrie gave you because it's quoted in the trial. Third, so in addition to no contemporaneous medical evidence represented by counsel, you have the evidence of the court clerk, which I accept only takes it so far, but again, you have no indication from the court clerk that there was any cause for concern raised. And then fourthly, you have the fact that Mr. Harrison, QC, didn't raise this issue when challenging the admissibility of Mr. White's statement or deposition during the trial. And this is important in my submission, because we know that Delano Harrison, trial counsel, was aware of the appellant's history of unfitness. And at the very least, we know from the exchange that he had in re-examination that he knew that his client was saying that he was very sick at the time of the preliminary examination. So he had material that, had he wished to, he could have challenged the admissibility of Mr. White's deposition, but he chose not to. And
so what construction do we put on that? Why would he have chosen not to?
Because, my lord, then this goes to the points we make in respect of diminished responsibility, that there is we say it is quite clear that a tactical decision was made not to raise diminished responsibility as a defence and not to put medical evidence pertaining to the appellant's mental condition before the jury, precisely for the reasons that were canvassed by the board, that you can't have, it's all or nothing, and a lot of evidence would have then gone before the jury as to a predisposition to sort of aggressive behaviour.
If you were arguing to the judge that the deposition of Mr. White shouldn't go in because of medical evidence, like Dr. Otti number 1, would that go before the jury?
Well, not necessarily, no, on the voir dire,
No.
The argument could have been advanced without then the medical evidence going
Why?
before the jury. I would,
So have you answered my question?
well, in answer to the question, all I can realistically submit is that Mr. Harrison knew that there was an issue as to mental condition at the date from the examination. And there was full argument as to why the deposition and also the statement shouldn't be admitted. And he did not choose to include within that argument any references to unfitness. And perhaps go further, that in my submission supports what I've said a moment ago, that there was no unfairness in the preliminary examination because of the full extent of the cross-examination. And really all that the appellant can now point to is, as I called it, the appellant going off script when he gave evidence, but only really in respect of bolstering his exculpatory case. I don't know why Mr. White said that. I don't even know Mr. White, is effectively what it boiled down to, which was obviously clearly rejected by the jury.
Had he told the police that he did know White?
No, I don't think so.
He hadn't, had he?
No.
Right. He hadn't said anything one way or the other, had he?
No. There are, I mean, insofar as it is material, I mean, there are suggestions. I think I alluded to earlier that there's a suggestion that the appellant clearly did know Mr. White. He refers to him as a cokehead, and there's a second reference to the fact that he knew him. But I accept that's really sort of outside of the trial. That's evidence that was given to his solicitor.
What was the relevance to the issues of whether he did know Mr. White? If identification had been an issue, then plainly whether he knew him would have mattered very much, because you're more likely to be accurate in identification of somebody you know than a stranger. But identification was never an issue. The appellant's case was he was there, but he didn't. But it wasn't he who fired a gun.
Yes.
So to what issue did it go, whether this witness knew him or didn't know him?
Well, my Lord, I say it's difficult to see what issue it went to, because your Lordship's right. The defence was, I was there, I didn't play a part. There was some cross-examination about, or the judge sums up along Turnbull lines. So the judge does identify some identification issues, really limited to distance and lighting and those matters. But I, in my submission, I say, and this really moves on to the second limb of my argument, namely, if there was some restriction on the appellant's ability to instruct counsel, I say that has insufficient impact on the trial so as to render the conviction unsafe, and this really goes to my Lord Toulson's point. The deposition statement and the statement that the appellant gave to the police were materially identical. As such, the substance of the deposition statement would have been available to the prosecution in any event. I know now Mr. Guthrie says that there should have been upheld objection to the statement going in. But I say it's only in very exceptional circumstances that the statement would have been ruled sort of inadmissible. And what happened here is you had the statement was allowed in, and an appropriate warning was given, as then modified by the Court of Appeal when they applied the proviso in this regard. And dealing with what I understand now also to be said, that really competent counsel should have objected to the statement of the appellant, or the statements of the appellant, and the question and answer records of the appellant going into evidence. That would be a rather extraordinary step for trial counsel to take in my submission, because what you have there are exculpatory, contemporaneous statements made by the appellant that you as trial counsel would want in evidence. And in all material respects, the appellant maintains his position throughout the trial, but bolsters it, as I've highlighted. So that, in my submission, deals with the question of deposition. The second point is the failure to raise diminished responsibility. Perhaps take this slightly quicker, and this is dealt with at paragraphs 57 to 82 of the respondent's case. And the first point to note is diminished responsibility is obviously an optional defence. In section 5.2 of the Offences Against the Person Act in Jamaica, identical to the law as it was in England and Wales, it's for the defence to prove the defence. And I don't understand now Mr Guthrie to be pushing the point that's made at paragraph 95 of the appellant's written case, which made reference to some provocation cases and suggested that it might be appropriate for a judge, if there was sufficient evidence, to really wade in and suggest that diminished should be run. I mean, that's simply not the case. And in our written case, there's reference to two cases, namely Kuchen, which, my lady, you'll find at tab 16, and Campbell, which you'll find at tab 10, and they make it quite clear that raising diminished responsibility is a matter for the defence, and only a matter for the defence.
You've got in the authorities Tate, where the board dealt with the question of raising on appeal issue of fitness to plead. You've not included in the authorities the Court of Appeal's seminal decision in Erskine and Williams on raising diminished responsibility on appeal, because it's been something which has cropped up in this country in the Court of Appeal again and again and again.
Yes.
Now, I think it's right to say that it has always been associated with the production of a fresh psychiatric report,
My lord, yes.
forming the basis of an application to adduce fresh evidence,
Yes.
which we don't have in this case.
No.
But that said, it sets out the approach adopted in this country towards applications to introduce DR on appeal not raised at the court below. And it's, or at least within England and Wales, authoritative. That's not in the bundle of authorities.
My lord, it's not. I contemplated including authorities that dealt with the point in England and Wales, but as your lordship says quite rightly, they are really fresh evidence cases where diminished responsibility is raised and in support of that a new psychiatric report. And for that reason, because we're not in fresh evidence sort of territory in this case, I didn't think it would be.
But I mean, to challenge it without fresh evidence to support the defence might be thought to be more radical.
Yeah, indeed, and no, don't get me wrong. I say it would be, yes. It's, it makes the it increases the sort of burden really that's on the appellant, especially in a case here where all the appellant is really able to hang diminished responsibility on is two aspects: a history of mental illness, which is not in issue, and a diagnosis of schizophrenia, and a single line in Dr. Otti's report that suggests there was substantial impairment at the time. But for reasons I can sort of go to now, take them slightly out of turn, we say even that is sort of insufficient to sort of cast doubt on the safety of the conviction. And Dr. Otti, and it's the point that's made at paragraph 79 of the respondent's case, we say little, if any, weight should be attached to Dr. Otti's statement in his report at page 570, namely that it's likely the illness would have caused substantial impairment. And we say that for a number of reasons that are summarised at paragraph 79. At first, he was reporting on fitness to plead, not diminished responsibility. Second, he had only examined the appellant on 2 occasions. Third, he was not the treating psychiatrist. That was Dr. Leveridge. And fourth, and perhaps most importantly, his opinion is given 4 years after the killing and does not appear to be based on anything that the appellant has told him about the offence.
Well, I suppose at least this can be said. It was surely the duty of counsel to find out what it was based on.
Yes.
There it is. On the face of it, it appears to be dealing with this very problem, namely, was the diminished responsibility. obviously a 3-line paragraph can't do the whole job for you, because there are all these other questions, as you say. But surely, leading counsel discharging his duty in accordance with his obligations ought to have been saying, well, now let's look into this. I'd like to learn a great deal more about it.
And that's what I say one can probably
Maybe that's
infer.
what went wrong in this case, I don't know.
Well, my lord, I say no with respect. I say that's what one can properly infer from the transcript, and that's the reference to Mr. Howson saying, frankly, I pondered, and he says pondered again.
Yes, but what basis did he ponder? We don't know anything about that, do we? It's a mere assertion that he pondered. He didn't do enough pondering. If he'd done enough pondering, we'd have a much clearer analysis of what he worked out and what the pros and cons were and so on.
Well, I mean...
Of course, he did have the problem that his client said he didn't do it, which is a bit of a snag, but...
Well, my lord, he had the problem that he said that I didn't do it, but also there was simply, other than Dr. Otti's sentence in that report and a history of mental illness, there was no other indicators that...
Well, there was a history of mental illness. There was at least a gap, or an apparent gap, between the time that he last took his medicines.
Yes.
And we all know that, well, everybody except me knows that if you are afflicted with these problems, if you don't take the medicine, then you're likely to be back in serious medical difficulties and might do all sorts of things you'd wish you hadn't done.
My lord, indeed, and this is the point I sort of started off with, really, which is they are all factors that one takes into account when, as competent counsel, considering whether to run a case of diminished responsibility. And obviously it has to be subject to your client instructing you to do so as well. But what we haven't got here, and I drew the distinction between the case of Robinson, is that, yes, you have got diagnosis of schizophrenia, history of mental illness, a year of apparently not taking medication. But then at the time, you have nothing that would indicate that he was labouring under a substantial sort of mental impairment at the time of the offence.
Please finish yourself.
Well, and just to make the point, he, in fact, the evidence would tend to suggest that he was acting entirely rationally at the time on his own case, namely running away from the scene and disposing of a jacket that he says might have incriminated him in the killing.
I don't see why you say this isn't a fresh evidence case when this part of the case is based on the report of Dr. Otti, which did not go before the jury.
Well, yes, and I have pondered to use the...
So this part of the case is based on fresh in the sense that it was material which didn't go before the jury, but of an extremely limited kind. What is really said is that of itself wouldn't have sustained a DR defence,
yes,
but would have put somebody on inquiry. But it does seem to me that the approach to fresh evidence is actually highly material.
Well, the reason I said it's not a fresh evidence case is perhaps taking a technical view of fresh evidence, namely material that was not available at the relevant time, and obviously this material was available. And
the first question in any fresh evidence case is, was it available at the material time?
yes.
And then the next question is, if it was available, why wasn't it used? And then the familiar questions follow.
My lord, yes. And I say, in answer to the first question, was it available? Yes, it was. Why wasn't it used? And this is where we are again in the realms of competence of counsel.
Because I think it's really said, I'm not sure how explicitly it's been put, but it's really being said. It was quite incompetent for counsel to have that quite important piece of information, and as far as we know, do nothing about it.
Yes.
And it's very troubling, it is said, and that we should do something about it.
That is what's being said. And I say, on the competence of counsel, we go back to the two cases, the Lawrence case, and where you really have to have you have to put the question to counsel, which has been put here. Mr. Howson's come back and said, with the greatest respect to him, he says simply, I can't remember anything really about this, and it doesn't take it any further. But what I say...
Well, that's rather unsatisfactory as well, right? But I suppose you can understand that.
Yes. It's an extremely high threshold, though, is the point that's made in the Campbell case and the Lawrence case. And although it's difficult at this remove, in my submission, the board should safely conclude that it was a tactical decision that was taken here.
You say it was a tactical decision, and moreover, when you look at the actual evidence that was given by the appellant at the trial. There's nothing incoherent about it at all, unlike the Robinson case where there were all sorts of things. So.
Yes. And
But what do we make of the fact that Mr. Delano Harrison, representing the appellant in the Court of Criminal Appeal, didn't make anything of it? He'd said during sentencing, well, if I'd known about this, matters might have taken a very different turn. He didn't seek to deploy it in the Court of Criminal Appeal.
well, my lord, I say that's entirely consistent with
That's how you read it.
with him making the tactical decision and his instructions being, we're not running diminished
Well,
responsibility.
are you saying he was dishonest in saying to the judge during sentencing, well, if I'd known about this, things might have been very different?
Well, my lord, I think this is where we are not necessarily at cross purposes, but perhaps with respect, I disagree with your reading of that
Yes,
passage
I
of the
see.
transcript.
Which goes back to what you were submitting before.
Exactly. I say what he's not saying there, he's not saying if I'd had this report, if I'd known about
No.
this. He's actually saying if there was some evidence on which
Yes, I see.
I can really run diminished responsibility, then I might have done. Or rather, I'd have at least explored it with my client.
Okay, thank you.
Can you tell us where we find the statement that the appellant gave to the police?
Yeah.
My lady, yes. It is,
48.
yes, it starts at page 47.
Right.
And that runs through to page 51, and at page 51, or at the very bottom of page 50, you then have a question and answer on the 30th of September. That runs through to page 55. Then you have the second question and answer session that takes place on the 2nd of October.
There's a slight oddity because the evidence of the police officer was, I think, the statement under caution came first and the questions came later. But the statement under caution is said to have been 8 p.m. on the 30th of September, and the questions which followed it are said to have been at 3:51 p.m. on
Yes.
the same day. So something's got a bit out of sync.
Well, yes, I mean that does seem to be the sequence on which.
We've got page 47, line 12,
Yes.
as the date and time of the caution statement,
Yes,
and page 50, line 25, has the date and time of the supplemental questions.
yes,
Well, it may just be that they were read in the wrong order. If you look at 47, I mean, it's quite obvious which one comes first, isn't it?
Anyway, there we are.
well, just to finish on this sort of diminished responsibility point. Obviously, the question really is, what is the evidence that the symptoms of schizophrenia were operative at the material time? And you have the points, and I won't repeat them now. Paragraphs 76 to 78 of the respondent's case, we identify 6 points in reliance on the contemporaneous medical records. And then at paragraph 81 of the respondent's written case, we say the jury would have also needed to consider those points that are set out there, which to a certain extent repeats a number of points that have already been made. And then if I just finally on conviction deal with what is said to be the wider use of the medical evidence. And I think what is being said, certainly in the written case of the appellant, what's being said is that suggests that certain inconsistency in the appellant's case and failure to put these to witnesses can be explained by his condition. I don't necessarily accept that for the two reasons we set out at paragraph 83 of the written case. First, that the appellant has given broadly consistent accounts of the events on the day in question. One only needs to compare the two accounts given to the police and the account given to Dr. Sewell when he reported his symptoms were adequately controlled. And the second point that I've already made, namely that the topics in which the appellant deviated can easily be explained by him wanting to bolster his exculpatory case. If I then move to sentence, and there's really 2 points on sentence: length of sentence, and what I mean by length of sentence is really length of time before parole can be considered, and commencement date of sentence. Take them in those order. The Offence Against the Person Act, as enacted at the relevant time, section 3, capital A, little 1, as we know, provided life imprisonment with a discretion regarding parole set at a minimum of 7 years. The appellant in this case was sentenced to hard labour with parole after 25 years. The short point in my submission is that there's no proper basis to interfere with the judge's sentencing in this case. There are 3 cases from Jamaica set out in the authorities bundle, tab 14, 15 and 18. I don't intend to take your lordships to them and ladyship to them, because you will derive some, I accept, limited assistance, because each case is going to turn its own facts. What they show there is that Ian Gordon, for example, which is at tab 14, shows parole being set not before 30 years. And that was at a similar time, namely around 2000, conviction in 2003. In my submission, the judge had sufficient evidence by the time he came to sentence about both the appellant's mental condition, and he properly considered it before passing sentence. And then the points that we make at paragraph 87 of our written case, there's no new evidence regarding mental state that alters the position of the sentencing judge. The crime was of sufficient gravity to justify the sentence that was given, and the judge found that the appellant was not operating under symptoms of his condition at the time of the offence. So I say there's no proper basis to interfere with setting a sentence with parole not before 25 years. Dealing shortly with the second point, the commencement date for sentence. There is a concession here in accordance with Tawari. We accept that sentence should run from the date of conviction, namely 23rd of January 2003. Beyond that concession, if the board saw fit to allow the appeal on sentencing on the time that should be given credit for, in my submission, the matter should be remitted back to the Supreme Court of Jamaica to determine, due to its
I think Mr. Guthrie recognised.
local knowledge and familiarity. I'm not in a position, looking at the authorities of Calacan and Dookie, I'm not in a position to provide any evidence as to, for example, different conditions that the appellant was held in at various times, whether it be on remand at the Governor-General's pleasure or after he was convicted.
But what you say about whether it's enough for the judge to say, yes, I see he's been in on remand for 4 years, 4 months, I'll take that into account, and then he goes straight into sentence, is that good enough?
My Lord, I say, perhaps on reflection, the judge could have explained his reasoning better, but I say...
Or at all, possibly.
I say what he acknowledges there, he acknowledges the relevant factor, i.e. the length of time that's been spent on remand, and he says, I've taken that into consideration.
Says this will be reflected in the sort of sentence. We are left not really quite understanding what reflection, how it was reflected, aren't we?
My Lord, I accept, as I say, there is not much in the judge's reasoning to explain how he arrives at the figure of 25
Well,
years.
Mr. Guthrie wants us to say not only that it should go back, which I think is common ground, but that it should go back with the observation that unless there's some very good reason why not, 4.5 years ought to be removed, 4 years and 3 months ought to be taken off the 25, which rather begs the question what the judge's starting point was, if there was one. But do you want to say anything about that?
My Lord, other than to observe, I mean, it really should be a matter for the Court of Appeal in Jamaica to determine, with its local knowledge, familiarity. I don't propose to say more.
They weren't asked to consider this, were they?
No, my Lord, they weren't.
No.
My Lady, my Lords, unless I can give any further assistance, they're my submissions.
Thank you very much, Mr. Bull. Mr. Guthrie.
There's one matter which I think hasn't been mentioned yet, but refers to the proceedings in the Court of Appeal in Jamaica, because the matter was raised with Mr. Poole as to whether or not Mr. Delano Harrison, not having mentioned anything to do with his client's mental state, that should be an inference that there was nothing to mention, so to speak, or he didn't think that there was. The original application for permission to appeal did raise a question as to his mental condition, and you find that at page 267. It's difficult to know whether he was represented at that stage, because the grounds of appeal aren't signed by counsel, but at B, so the prosecution failed during the trial to present any form of substantive material evidence for a conviction, especially my medical and psychiatric record from Ward 4, University of West Indies, and the Bellevue Hospital.
If anything, that might, because what happens then is, am I right, Mr. Harrison comes in and effectively abandons the
No,
self-written
that isn't
grounds.
what happened.
No?
This application was refused.
Ah, yes.
And so Mr. Harrison produced additional supplementary grounds which they permitted him to argue.
And those were the only ones argued. Yes, I see.
Yes. I would respectfully submit that the concerns as to whether or not there was a miscarriage of justice in this case have not been removed by examination of the circumstances in detail. We start with the proposition that the appellant, on any view, was an extremely mentally ill person. And the evidence is certainly that he was an extremely mentally ill person when the offence was committed. One then goes to the other end of the case, to the what transpired after he was convicted at the trial. And it's my submission that nothing that has been said detracts from the fact that the judge was plainly taken by surprise when he discovered that the defendant had been the subject of previous proceedings at which he was unfit to plead. There is nothing to suggest that Mr. Delano Harrison had any more than the most superficial knowledge that his client had been mentally unwell in the past. It is not clear that he knew he'd been found unfit to plead, and indeed all the matters which my learned friend relies on to suggest that the situation was clear at that stage only apply to the final sentencing stage on the reconvened hearing on the 23rd of January. There is nothing to suggest that when this man was tried by the jury, either the judge or his counsel knew anything like the extent of the mental difficulties that he had experienced in the past. Now, what was said ought to have been a trigger to investigate much more closely what had happened. But we're now in a position to look in a little more detail at what happened. And we again go back to the pre-offence days when we know that it appears the appellant was very mentally ill, that he was not compliant with the medication, that he was subject to a prescription of a year before of fairly serious medication to control his illness. There was then an incident at which he says he was not a party to the offence of murder. If I can just pause there and deal with Mr. White. It is not clear that he did know Mr. White from the affidavit which was sworn by Mr. Wright in the matter. It's only clear that when Mr. Wright saw him, he described Mr. White as a cokehead and immediately said that he now knew who the persons responsible were as killer and shotter. But there's no, it was plainly important to the proceedings that Mr. White was the only witness who gave evidence upon which the jury could have found that the defendant was guilty of murder. So I come to the next stage in which I submit it is not clear that justice was done, which is in relation to the committal proceedings. I mean, it is a hard thing for someone to be convicted of the offence of murder simply on the evidence of a statement which is read to the jury and which cannot be cross-examined upon at his trial. So rightly, the law in Jamaica, just as elsewhere, provides for safeguards to prevent the admission of that evidence in certain circumstances. And the circumstance in section 34, which is the section which admitted the deposition, requires there to have been a proper opportunity to cross-examine the witness. And we know that at the time of that opportunity, the appellant was seriously mentally ill. It must be, on the balance of probabilities, the case that at that time he was unfit to plead, because we had seen the evidence on both sides of that date. The evidence that he gave at his trial, which you saw just a short time ago, was at page 201 of the record. He could not remember the committal proceedings at all. That's at page 201. He was asked whether he had ever seen the witnesses come to court. He said he had never seen any witnesses. Now, he was convicted, therefore, on the read evidence of a person who, in our submission, it's quite clear he never had a proper opportunity of challenging while that person was alive. And if that is the case, that is the end of the matter, because, as I say, it is a hard matter to convict a person on that kind of evidence. And if the safeguards which the legislature have put in place are not observed, then that is that. It's no good saying, well, the statement said much the same thing, because he wasn't tried on the statement, he was tried on the deposition. If that deposition was inadmissible, it was part of the case against him. But in any event...
Was he tried on both, Mr. Guthrie?
Yes, but you can't say that he wasn't tried on the deposition.
No, I follow
Because he was. I mean, that is my point.
But if they do so, all right, well...
But you can't say that the jury might have only convicted him on the statement and not on the deposition. The deposition was before them. It shouldn't have been. It was a vital part of the prosecution case, a central plank of it. If it shouldn't have been there, then the conviction must surely fall away.
Unless they say exactly the same.
Which, that begs the further question that if Mr. Harrison had had any knowledge or any complete knowledge of his client's mental difficulties in the past, he would have had strong ground for opposition to it going in.
To the statement?
Yes.
Yes, I see.
And one cannot possibly say, sitting here in 2015, what the results of any of such applications by Mr. Harrison might have been. If he had drawn the attention of the judge to the fact that his client was plainly mentally ill at the committal proceedings, the judge might very well have said, well, Section 34 is a section which is to protect the position and ensure that justice is done. It's not being complied with, or that will not go in. And in the circumstances, I don't think it's right to exercise, well, I will exercise my discretion to exclude the statement, which there's no doubt that he had such a discretion, and it's no good now saying he would inevitably have exercised it one way rather than another. So the jury then found that the defendant was fit to plead. And I've made my submissions as to the fact that Section 25 of the Act in Jamaica provides a protection for a person in the defendant's state. In other words, the jury he's put in charge of the jury, and the jury make the decision. It is suggested that, well, once they've made that decision, there is no need for any further consideration by the court. And it's suggested, well, it looks very much as though there might have been some further application, for example, in front of Mr. Justice Harrison, but we don't know that. And if one looks at the DPP's letter, which you had today, it doesn't even seem with respect that the procedure which she outlines in that letter was followed. She says that after the defendant is found unfit to plead, he will be kept in custody at the pleasure of the Governor-General, would receive the necessary medication. In addition, continually evaluated. If there is improvement in his condition, a report from the attending psychiatrist is sent to the court. She then says the defendant is placed again before the court so that the matter can be dealt with. There is no other trial of the defendant's fitness as the psychiatric report is deemed sufficient. But in the present case, as I've said, there is no apparent support for the view that the judge at the trial, the trial court, actually ever did, before the trial took place, receive a psychiatric report, or that the matter was raised by at the court of trial. Because, as I've said, the only way in which the passage of the 16th and the 23rd of January, those two passages following the verdict, can be read, is to the effect that the judge was extremely surprised to hear of the previous events. And he did not know before then that there had been a finding of unfitness to plead, or indeed it appears that he does not know anything about the mental affliction which the appellant was suffering from. Otherwise, why does he react in the way that he does, saying, well, nothing about the evidence that I heard suggested there was anything mentally the matter with him? It's quite apparent that he simply didn't know. And at the very least, if the report had been before him, as the DPP says would have been the case, he would have, as I think my Lord Hughes said, raised the matter with counsel, saying, well, is there a mental issue? And then counsel might well have been put on his guard and done exactly what my Lord Clark suggested might have been the right thing to do, would be to investigate with a good deal more care than he did. But since it doesn't appear that he knew any more than that there's a history of some mental illness, which meant that he had not previously been tried, he didn't know, apparently. It certainly doesn't appear that he knew there'd been a formal trial of the unfitness to plead issue. Then that safeguard, which the observation of the procedure would have ensured, didn't take place. So the trial proceeded in the ignorance of the judge, and we would say all but the most superficial way, in the ignorance of the defendant's counsel, of the true extent of his mental disability. So at the end of the day, my lords, surely one is left with the impression that the proper safeguards which would ensure the due administration of justice and a just trial for this defendant simply were not met. And in those circumstances, the matter should not be, the conviction should not be allowed to stand. And my lords, that is really the bulk of what I want to say. It is, we would respectfully say, a wholly unusual situation where at the end of the day, almost the last thing said in court is a reference by a judge to a medical report in which the statement is made in terms by the judge from reading from the medical report. I can just, I'm sorry, I need the end of volume 1 again. It is likely that the illness would have caused substantial impairment of his mental state at the time the offence was committed.
What page are you reading from?
It's page 263. It's the passage which you've seen before.
Yes.
And then Mr. Harrison says, if I had had that kind of information, there may have been a different approach to the conduct of the defence, the question of the level of responsibility. If that is effectively the last thing said before sentence, and that does not ring the greatest of alarm bells as to whether or not this was a fair trial, one tempted to say, well, what does? Because there's no doubt at all that Mr. Harrison is referring to what the judge has just put to him. And it's very well to say, well, those are 2 or 3 lines, which is a small peg on which to hang a submission. Plainly, they don't of themselves give rise to fresh evidence of diminished responsibility, but what they do is indicate that there is cause for very grave concern, and they aren't to be read on their own. They're to be read in conjunction. The words, it is likely that this illness would have caused substantial impairment of his mental state at the time the offence was committed, they're to be read in conjunction with the medical evidence that you've seen, that this was a very ill man who was apparently suffering from severe schizophrenic auditory hallucinations, delusions, and in those circumstances, one cannot be satisfied that his conviction was just. And that's the way in which we put the case, and suggest that taken together those matters must amount to a real risk of a miscarriage of justice. On the question of sentence, I think I need it appears from the cases that in ordinary circumstances, the practice in Jamaica is to backdate to the date of conviction. But of course, that is ordinary circumstances. And I would respectfully suggest that this being the case it must be a case for remission to the Court of Appeal to consider the position. But I would strongly suggest that my Lord Hughes referred to my suggestion. In the case of Ali and Tiwari, and in the Mauritian cases, the point is made that whatever the statutes may say, justice requires an even-handed approach, and that if a man is in custody, that must count towards his sentence, unless there's some extremely good reason to the contrary.
Do we know what the response view is if we were to allow the appeal?
Why don't we ask? Yes. Mr. Poole.
I think I heard.
Did you hear the question?
I think you heard the question.
I don't think you addressed the question. But the question is whether, if we were to allow the appeal, whether we should obviously have to consider what should happen next. Now, I'm not sure if you've made a submission so far as to whether we should direct what we should do. Should we direct a retrial or what?
My Lord, I've sought instructions, and I'm without instructions on that specific point, but I can obtain instructions, and then perhaps the easiest way. I don't think I'll obtain instructions in the next 5 minutes. I can see the force, though, given the length of time.
Yeah, will you
Well,
make
it would depend entirely on, it would depend first and foremost on the basis of it, because if it be right that Mr. White's evidence was inadmissible, then there could be no shadow of doubt but that the conviction should be quashed. If, on the other hand, that evidence was admissible, but there was an irregularity in not exploring with the appellant the possibilities and the pros and cons of running a diminished responsibility defence, then all sorts of other things come into play. For example, whether the minimum conviction in those circumstances would have been a conviction of manslaughter. I mean, there's a range of questions, but you would need to know, first of all, what the board's decision on the contested issues is, wouldn't you?
Yes. My Lord, yes, because we are in the rather peculiar circumstances that, as you say, Mr. White, obviously his evidence, in terms of retrial, the length of time is not necessarily as problematic as it sometimes is because of the nature of the evidence.
Well, if it was inadmissible, and that's
I
it.
accept that.
Well, even that dawned on me.
But if there's some other reason of a real risk of a miscarriage of justice, well, then there may be all sorts of things for
Yes.
those instructing you to consider.
Yes.
That's the position, is it not?
My lady, it is.
And presumably you say, do you, if it comes simply to the question, depending on the findings, if it were to come simply to the question of whether as a matter of discretion there should be an order, or not of discretion, of judgment, there ought to be a retrial or not, that's better for the local court than for us.
Yes, I would say for the Court of Appeal rather than the board, my Lord, yes.
Well, you can see practical arguments against. If the minimum was manslaughter diminished and he served a very long period of time inside,
Yes.
to have a retrial X years after the event on the issue of murder versus manslaughter might not be in the public interest, but one would have to see your written submissions.
My Lord.
I think you did.
Well, this is all the deepest of speculation, because, of course, the board has not yet considered what advice it will humbly offer to Her Majesty. We will take time to do so, and the board is now adjourned. Thank you all very much for your assistance, and particularly to those who worked so hard pro bono to discover all this new material for us. We're most grateful to you.